Hello, I'm Jaspreet on this side. I'm Company Secretary by profession, and this is seventh video on revision of Companies Act. Disclaimer alert that this is only for the purpose of revision and going through various concepts just to brush up our memory. Okay, let's start. We are using Saransh by Institute of Chartered Accountants of India. I find it graphically very appealing, and therefore we are revising Companies Act through this Saransh. Okay. So next, in last video, in our sixth video, we had covered around share capital, means alteration of share capital, reduction of share capital, further issue of share capital, bonus issue. We covered all those topics, and even restriction on purchase of company's own shares by the company, especially for public companies, and then exceptions there too. Okay, now next we are covering power of company to purchase its own shares. Now section 68 gives power to a company to purchase its own shares, which is called buyback. Buyback is a reacquisition by a company of its own securities. It is a way of returning money to its investors. Section 68 contains provisions which describe the power company to purchase its own securities subject to the applicable conditions. Subject to certain conditions, company can purchase its own shares and return the money to the investors. Now, sources of funds for purchasing should be made out of. Now, what are the sources? Purchasing can be made only out of these funds. Now, first is free reserves. If the company has free reserves that can be utilized, securities premium account. If securities funds in securities premium account is available, then that can be utilized, or proceeds of the issue of any shares or other specified securities. We have received the money, it is pending unutilized, and therefore we are paying it back to reduce share capital. Means buy back our own shares, not to reduce share capital, just only to buy back the shares of the company. Now, these are the sources, means funds will come from free reserve, securities premium, and proceeds. While designing, suppose if we have all three available, then which one should be utilized? Like, here's a hint: free reserves can be utilized for many purposes. However, securities premium have restricted purposes, and proceeds of the issue are also specified the purpose for which it can be utilized. So, the most restricted should be utilized for the most restricted works, and if those funds are not available, then free reserve should be utilized. This is ideal strategy which we should follow. Now, conditions for buyback. These conditions need to be satisfied before attempting a buyback, before planning a buyback. Now, authorized by the articles. Articles must clearly authorize a company to buy back its own shares. Number two, special resolution authorizing buyback passed in general meeting of the company. So a special resolution is passed, approval of members by 75% majority of voting in person. The amount involved should not be more than 25% of the aggregate paid up capital plus free reserves. So, how much you can buy back? That amount cannot exceed 25% of aggregate paid up capital plus reserves. Aggregate paid up capital means capital paid up capital includes equity shares, equity shares with differential voting rights, preference shares, complete paid up capital plus free reserves. These 25% is the maximum limit up to which buyback can be attempted. In case of buyback of equity shares, the maximum limit is 25% of its total paid up equity capital in any financial year. Means if in a financial year we want to buy back, then maximum we can buy back 25% of its total paid up equity capital. So buyback of equity is restricted to 25% of total paid up equity in a financial year. After the buyback, the ratio between the debt, secured and unsecured, owed by the company should not be more than twice the paid up and twice the paid up capital and free reserves of the company. Central government may prescribe a higher ratio. So at present the ratio is that after the buyback, the ratio of debt owed by the company should not be more than twice the paid up capital. So we comes with debt to equity ratio is 2 is to 1. Paid up capital plus free reserves. Paid up capital plus free reserves. So paid up capital plus free reserves, and the debts owed to the company cannot be twice this amount. And this scenario we are seeing after post buyback. So we will take post buyback paid up capital and free reserves and then compare whether debt secured and unsecured owed by the company will be twice that or not. If they are going exceeding the twice, then the buyback cannot be attempted and central government may change this ratio also. Next is shares or other specified securities for buyback shall be fully paid up. Only fully paid up shares can be or securities can be attempted to be bought back. The buyback should be as per Rule 17 of the company's share capital and debentures rules 2014. So this should be attempted as per Rule 17. In case of listed shares or other listed specified securities, should be as per regulations made by SEBI in this behalf. So if listed shares or listed securities are attempted to be bought back, then regulations made by SEBI will also needs to be complied with. Procedure before buyback. So now before we attempt to buy back, the notice of the meeting at which special resolution is proposed to be passed shall be accompanied by an explanatory statement stating the particulars related to buyback. So notice of the general meeting for passing special resolution will contain explanatory statement state which will state the particulars relating to buyback. Securities to be purchased under buyback. Buyback may be from which now buyback may be from whom buyback can be attempted from the existing shareholders or security holders on a proportionate basis. So proportionately buyback can be attempted from existing shareholders or existing security holders, or buyback can be attempted from open market, or in case of obviously listed company, buyback can be attempted from open market or securities issued to employees of the company pursuant to scheme of stock option or sweat equity. ESOPs and sweat equity both are covered. Point is employees, so we can buy back from existing shareholders, buy back from employees of the company, and buy back from the open market. All three options are available. Existing shareholders proportionately, open market whosoever is selling, and from the employees as per scheme, or those employees whom sweat equity was offered. Sweat equity we learned that was can be offered to directors or employees of the company against their sweat, means value addition, intellectual property rights brought in to the company. And sweat is issued for consideration or discount, or normally discount is not allowed, but sweat equity can be issued at discount or for consideration other than cash. So from employees we can buy back, from open market we can buy back, from existing shareholders on proportionate basis we can buy back. Time limit for completion of buyback. Buyback shall be completed within 12 months from the date of passing of special resolution or board resolution authorizing the buyback. So raising the buyback, authorizing the buyback. Next is cooling period on buyback. 6 months. Now official cooling period for buyback is 6 months. With respect to further issue of same kind of shares or other specified securities, what we mean by cooling period is that once you have bought back shares, then similar or same shares cannot be issued to the market within next 6 months. So you should not attempt buyback and then further issue same kinds of shares or specified securities. So there is 6 months cooling off period requirement, that what you have bought back you will not issue same securities within next 6 months. So these were the various conditions relating to buyback, that Its source can be free reserve, securities premium, proceeds of the issue. Then conditions are authorized by article, special resolution. Then it cannot exceed aggregate of 25% of aggregate paid up capital and free reserves, and in case of equity, 25% of total paid up equity in a financial year. Then ratio debt and equity plus free reserve. Debt is to paid up capital and free reserve ratio should be 2 is to 1, or central government may specify a higher ratio. Shares or other securities buyback should be fully paid up. Buyback should be as per Rule 17, and in case of listed company, regulations of SEBI needs to be complied. Procedure before buyback. Buyback notice is to be sent giving an explanatory statement containing all the particulars about buyback. Then buyback can be done from existing shareholders, employees, or open market. Then time limit, in 12 months we have to complete buyback. Time 12 months start from the date of passing of special resolution or board resolution where buyback is authorized, and cooling period is 6 months. That is, within next 6 months of buyback you cannot issue same class of securities. Next we move to prohibition for buyback in certain circumstances. Section 70. In certain circumstances, buyback is prohibited. No company shall directly or indirectly purchase its own shares or other specified securities under the specified circumstances. So no company shall purchase. Prohibition. Prohibition for purchase of its own shares. Prohibition is in case of through any subsidiary company including its own. So neither it can buy back through its subsidiary companies or through any investment company or group of investment companies. So like we have subsidiaries, we have associates. Associate is one where you already own 25% shares or more, but investment company is one which has invested in your shares. So if there is a company which is holding your shares in your company, then you cannot buy back from that company. So buyback from investment company is not allowed, or any investment group company buyback is not allowed. From subsidiaries buyback is not allowed. If a default is made by a company, so if these defaults are existing, then also buyback is not allowed. In respect of repayment of deposits or interest thereon, redemption of debentures, buyback is not allowed. Redemption of preference shares, buyback is not allowed. If there is default in redemption, if there is default in repayment of deposits or interest, if payment of any dividend is pending, buyback is not allowed. If preference shareholders are not being paid dividend, buyback is not allowed. Repayment of any term loan or interest thereon to any financial institution or banking company. So if there is any bank term loan which is pending repayment or any interest is not paid, then buyback is not allowed. So in case of default in meeting repayments as to deposits or interest, redemption of debentures, preference shares, non-payment of dividend, or any non-payment of term loan interest from financial institution, banking company, if these are there, then buyback is not allowed. From subsidiaries not allowed, from investment companies not allowed. Also, prohibition on the company to purchase its own shares or other specified securities in case such company has not complied with provisions of. So there is provision on purchasing its own shares if following provisions are not complied. If the company has not filed annual return under section 92, if the company has declared dividend but has not paid or has not complied with section 123 relating to declaration and payment of dividend, if the company has not complied with section 127 relating to punishment for failure to distribute dividend, there was an issue relating to distribution of dividend, or if there is non-compliance with section 129 relating to financial statements, annual return. So annual filing is a concern, dividend payment is a concern, then buyback is not allowed. Annual filing is concerned, dividend we have already covered earlier also, but any non-compliance relating to complete section, so its scope is wider. Next, we proceed to debentures. Okay, so about debentures. Section 71 relates to debentures. Debenture includes debenture stock, bond, any other instrument of the company evidencing a debt, whether constituting a charge on the assets of the company or not. So, debentures are also kind of debt, debt, debenture stock. So it is debentures, bonds. Earlier, I used to get confused with the word bond. That where is bond word coming from? So we see issue of bonds in the marketplace, but that word is synonymous with debentures. So bonds and debentures are synonymous. Debenture stock, bonds, any other instrument of the company evidencing a debt. So it is an instrument, it is evidencing a debt of the company, whether constituting a charge on the assets of the company or not. So it can be secured or it can be unsecured. So there can be secured debentures, there can be unsecured debentures, there can be secured bonds, there can be unsecured bonds. So they are evidencing that there is a debt. However, charge may be created and charge may not be created. Debentures exclude what is not covered in debenture. Instruments referred to in Chapter 3rd-D of the Reserve Bank of India and such other instruments as may be prescribed by central government. So all the instruments provided by RBI or central government which are clearly provided that these are not debentures. Okay, then these are not debentures. Apart from that, usually what companies, corporates issue are in the nature of debt. Acknowledging a debt is in the form of debentures or bonds. Types of debentures. So debentures can be divided into various types depending on the basis of security, whether they are secured or unsecured, on the basis of convertibility, whether they can be converted into shares or not, on the basis of redeemability, whether they will be redeemed or not redeemed at a later point of time. So secured debentures or unsecured debentures. So debentures can be secured, unsecured, bonds can be secured, unsecured, convertible mandatorily or optionally, partially or fully. So it can be mandatory to convert, it is an option on the part of company to convert, or it is an option on the part of debenture holder to convert, or it is an option on the happening of certain event, on the happening of certain terms and conditions, on the fulfillment of certain terms and conditions, then it can be optionally converted partially or fully, then whether they will be fully converted or partially converted. Certain portion will get converted and certain portion will get repaid. So all these options are there based on convertibility into shares, and non-convertible means those debentures which cannot be converted into equity shares. On the basis of redeemabilities, they can be redeemable or irredeemable, means at the end return payable or non-payable. Manner of issuing debentures. Manner. How are debentures issued? So number one step is authorized by special resolution at general meeting. Then company may issue debentures with an option to convert such debentures into shares at the time of redemption. So manner of issuing debentures is authorized by share capital, authorized by special resolution at general meeting. Then company may issue debentures with an option to convert the debentures into equity shares at the time of redemption. So if we are giving an option to a debenture holder, bond holder to convert into equity shares at the time of redemption, then that must be authorized by a special resolution. That can be done only with the approval of shareholders, majority shareholders, 75% present and voting shareholders of the company, or if by ballot, then majority, at least 75% voting of all those who are voting. Secured debentures may be issued by the company as per Rule 18, Sub-Rule 1 of the company Share Capital and Debenture Rules 2014. Then maximum period of secured debentures. Maximum period up to which a debenture, secured debentures can be issued is shall not be more than 10 years from the date of issue, except in prescribed cases can be up to 30 years, like in case of infrastructural companies, or there are conditions in certain cases the maximum tenure can be 30 years, and ideally the maximum tenure of secured debentures is 10 years. Appointment of debenture trustee. In case of secured debentures, debenture trustee will have to be appointed by company before the issue of prospectus or letter of offer for subscription of its debentures. Before subscription, before offer is made, then debenture trustee is to be appointed. Securities can be by way of creation of charge or mortgage in favor of debenture trustee on specified movable properties of the company, or on specified movable properties of its subsidiaries, or on specified movable property of its holding company, or on specified movable properties of its associate companies. So movable property, charge on movable property can be of the company itself, its subsidiaries, its holding, or its associates. However, for charge on immovable property, so it means charge on immovable properties only on the company wherever situate any interest therein, either complete immovable property or any interest in that immovable property. Charge can be created. Debenture trust deed shall be executed in form 12. So debenture trust deed shall be executed with debenture trustee in form 12 to protect the interest of debenture holders. Debenture trust deed contain various terms, means it contains duties of the company's debenture holders and powers of company and debenture holders, and what all the debenture holder require compliance from the company on quarterly basis, monthly basis. So all the terms are provided. So debenture trust deed shall be executed in Form 12 to protect the interest of debenture holders within 3 months of closure of the issue or offer. So we find that before issue, before letter of offer or prospectus is out, debenture trustee needs to be identified and appointed, and then after appointment of debenture trustee, then after allotment, when the offer and when the close issue is closed, offer is made, money is received, then on after within 3 months of closure of the issue or offer, then debenture trust deed needs to be executed. Okay, so next we move to registration of charge. So charge, let's start in our next video. So far in this video we have covered debentures, issue of debentures. We have covered prohibition of buyback in certain cases, buyback related provisions we have covered in this video, and power to purchase his own shares. So these are all what we have covered in this specific video. I hope this was relevant and important. Disclaimer again that this is only for knowledge sharing and revision purpose and no other purpose. Thank you.